The clock struck exactly 10:03 a.m. Eastern Time this morning, and at that precise moment the Supreme Court of the United States issued a ruling that was brief in length, but absolutely massive in consequence. In a decision that will likely be studied by legal scholars for years to come, the High Court denied an application in one of the most significant legal battles of our time. What makes this ruling so stunning is the unity behind it. All 9 justices were in complete agreement. There was not a single dissenting voice, no separate opinions written, and no debate left on the table. The entire judgment consisted of just 2 words: application denied. If you want to stay ahead of breaking legal news like this, please take a second to subscribe to the channel and turn on notifications so you never miss a critical update. With those 2 simple words, months of intense legal maneuvering and fighting came to a screeching halt. But to truly understand the weight of this morning's decision, we have to look at the timing, because this ruling arrived exactly 72 hours after lawyers representing Melania Trump submitted a very specific, high-stakes agreement to federal prosecutors. In that document, she laid out in detail the evidence she is prepared to provide in exchange for potential immunity from prosecution. We are looking at 2 monumental legal events occurring just 3 days apart, and the timing tells us that they are inextricably linked. Before anyone brushes this off as mere gossip or sensationalized internet rumors, it is crucial to understand that every piece of information we are discussing today comes directly from court filings, official legal agreements, and orders issued by the Supreme Court itself. These are matters of public record, not anonymous whispers or leaks from unnamed sources. These documents are available for anyone to verify. And here is the reality of what has now become legally official. Melania Trump has voluntarily waived her spousal privilege. For those unfamiliar with the term, spousal privilege is the legal protection that typically prevents prosecutors from forcing a husband or wife to testify against their spouse. In this instance, she has given up that protection of her own free will. The evidence she is bringing to the table falls into 3 distinct and damaging categories. First, there are financial documents that reportedly demonstrate she had knowledge of dishonest property valuations. Second, there are communications, including specific discussions regarding property values and the paperwork for loans. And third, there is her own direct testimony as a witness, which is expected to corroborate what accountants and bankers have already told a grand jury while under oath. Because the Supreme Court has now rejected the final appeal, the road has run out for the defense. There are no legal avenues left to block this. There are no more appeals to file, no strategies left to delay the process, and no procedural tricks remaining in the bag. The grand jury is now free to hear her testimony, potentially within a matter of days. Adding to the pressure is the calendar. Her former husband's confirmation hearing as a cabinet nominee is scheduled for early March, which is only about 6 weeks from now. To understand how we got here, we need to walk through exactly how the last 72 hours unfolded, because the sequence of these events was anything but random. It began on Monday afternoon at 2 p.m. Eastern. At that time, Melania Trump's legal team handed over a document to the special counsel's office known as a Proffer agreement. In plain English, think of a proffer as a preview or a trailer for a movie. The witness is essentially telling prosecutors, here is what I know, here is what I am willing to say under oath, and here is the physical evidence I can give you. In exchange for this preview, prosecutors consider granting the witness immunity, meaning they cannot be charged with crimes based on the testimony they provide. While this is a standard procedure in federal cases, what makes this specific proffer extraordinary is the identity of the witness and the magnitude of what she is offering. Then came Tuesday afternoon, again at 2 p.m. Eastern. Exactly 24 hours after the proffer was submitted, the defendant's legal team filed an emergency appeal to the Supreme Court. Their goal was to get the court to step in and block her testimony before the grand jury could hear a single word. Their primary argument was that allowing a spouse to testify violates marital privacy protections guaranteed under the Fifth Amendment. Now, filing a complex emergency appeal in just 24 hours is incredibly fast. Usually, appeals of this nature take weeks to draft and refine. The fact that this was filed so rapidly strongly suggests that the defense team knew this was coming and had been preparing their counter-move well in advance. By Wednesday morning, the Supreme Court had officially received the appeal. They assigned it a case number and put it on the schedule for review. But here is the detail that legal experts noticed immediately. The court did not issue a stay. A stay is a legal pause button. It stops everything in its tracks while the judges think things over. When there is no stay, the legal machinery keeps grinding forward even while the court considers the question. This silence from the court was deafening. When the Supreme Court issues an immediate stay, it usually signals that the justices believe the argument has some validity. When they let the process continue without hitting the pause button, it usually indicates they are skeptical of the argument. Then came this morning, Thursday, at 10:03 a.m., when the Supreme Court delivered its final answer in that single sentence: application denied. There was absolutely no dissent from any justice. Justice Thomas did not disagree. Justice Alito did not disagree. Even Justices Gorsuch, Kavanaugh, and Barrett, all appointed by Trump, did not offer a single word of disagreement. It was a complete unanimous rejection. Typically, when the court writes an opinion, even a short one, it means the legal question raised was complex enough to require some explanation. When they simply issue a one-sentence denial with zero disagreement, it implies that the appeal wasn't even worth a discussion. In more than 3 decades of watching the legal system, I have only seen this kind of total, silent rejection a handful of times. In every instance, it meant the legal argument was so fundamentally weak that it didn't deserve the court's time to explain why it failed. So that is the full 72-hour timeline. The proffer landed on Monday. The emergency appeal was fired off on Tuesday. The court took the appeal but refused to pause the case on Wednesday, and the application was flatly denied on Thursday. Now, we need to talk about what is actually inside that proffer agreement, because the evidence she is offering is far more serious than the headlines might lead you to believe. As mentioned, the agreement breaks the evidence down into 3 categories. The first category involves financial documents proving she was aware of dishonest property valuations. This includes the fact that she signed joint tax returns from 2014 through 2020. That is 6 years of tax filings where both spouses signed their names under penalty of perjury, swearing that the financial information contained within was accurate. These tax returns rely heavily on the valuation of assets, essentially what properties are worth, how much income they generate, and what tax deductions can be claimed. If those property values were inflated when shown to banks to secure loans, but then deflated when reported to tax authorities to lower the tax bill, you are looking at both bank fraud and tax fraud. And here is the kicker: a signature on a joint return creates legal liability for both people who signed it. The proffer also states that she was physically present at meetings with accountants where these asset values were discussed. She even reportedly asked questions regarding how the properties were being reported. All of this is supported by emails that are already in the hands of the prosecutors. If you are finding this deep dive into the legal process helpful, please hit that like button to help this video reach more people who want the facts. The second category of evidence involves communications. This includes text messages exchanged between her and the defendant, where they discussed property values right before meetings with lenders. It also includes emails with accountants where she explicitly questioned the discrepancies between the numbers given to banks and the numbers reported to the IRS. Furthermore, there are recorded phone conversations where specific property values were discussed in direct connection with loan applications. In federal cases, if she recorded those conversations in compliance with consent laws, those recordings are admissible as evidence. If she is offering them as part of a proffer, you can be certain that prosecutors have already rigorously vetted them to ensure they are authentic. The third category is witness corroboration. She is in a position to confirm what accountants have already told the grand jury. She can back up what bankers have testified to under oath. She can support the claims of property appraisers who said they were pressured to inflate property values beyond reality. In the world of federal prosecution, corroboration is the golden ticket. If one witness claims they were in a meeting where fraud was discussed, that is strong evidence. If a second witness says, "I was in that same meeting and I confirm that is exactly what happened," the case becomes stronger. If a third witness then produces documents from that very meeting showing the dishonest values, it creates a pattern of evidence that is nearly impossible for any defense team to dismantle. But the biggest legal shockwave buried inside this proffer is the waiver of spousal privilege. In the vast majority of cases, a spouse cannot be compelled to testify against their partner. This rule exists because the law values the sanctity of marriage and believes the legal system shouldn't be a wedge that destroys marital trust. However, spousal privilege is something that can be given up voluntarily. Her proffer agreement explicitly states that the privilege is waived for all matters discussed in the agreement. This isn't a case of prosecutors twisting her arm to cooperate. This is her making a choice to cooperate on her own terms. We have seen spousal cooperation before in organized crime cases, where the wives of mob figures testified to ensure their own safety. We have seen it in corporate fraud cases, where the spouses of executives cooperated after realizing they were in legal danger themselves. But this is the first time in history, at this level, where the defendant once held the highest office in the land, that a spouse has come forward with financial records, private communications, and direct testimony. The defendant's emergency appeal to the Supreme Court attempted to make three main legal arguments, and every single one of them failed. The first argument was that spousal testimony violates the marital privacy protections of the Fifth Amendment. However, there are 150 years of Supreme Court rulings establishing that spousal privilege can be voluntarily waived. The landmark case here is Trammel v. United States from 1980. In that case, the court ruled that the witness spouse is the sole holder of the privilege. That means the decision to testify belongs exclusively to the witness, not the defendant. If the witness chooses to waive that privilege and speak, the defendant has no power to stop them. That ruling has stood for decades and is followed by every federal circuit court in the nation. Consequently, this argument had absolutely no legal footing. The second argument the defense mounted was that the proffer agreement was obtained through force, threats, or undue pressure from prosecutors, rendering the testimony involuntary. However, the filing includes a sworn statement from her own attorney declaring that she was the one who reached out to the special counsel's office first. Her lawyer initiated the contact, her lawyer proposed the cooperation, and her lawyer negotiated the terms. There was no subpoena issued, and there were no threats made. The proffer was entirely her decision. Federal courts use a very clear standard to determine if cooperation is voluntary. Was the witness threatened with charges if they refused? Was their potential criminal liability used as leverage? If the answer to both is no, and the witness approached prosecutors proactively, the cooperation is voluntary. The sworn statement from her lawyer completely dismantled the claim of coercion. The third argument was that allowing this testimony would set a dangerous precedent that could destroy marital privacy in all future cases. But the reality is that the precedent already exists. Spouses testify in federal cases regularly when they choose to do so. The Trammel case settled this question back in 1980. What the defense was actually asking for was a special exception based solely on the identity of the defendant. The Supreme Court does not, and cannot, create exceptions based on who a person is. The law applies equally to everyone. So, when the court issued that one-sentence rejection with zero disagreements, the message was crystal clear. The arguments weren't just weak, they were viewed as frivolous. To win an emergency appeal at the Supreme Court, you have to demonstrate that serious, irreversible harm will occur and that you are likely to win on the legal merits. This appeal failed to show either. Having testimony heard against you is simply the justice system functioning as intended. And winning on the merits would have required the court to overturn the Trammel ruling, which not a single justice was willing to entertain. With the Supreme Court appeal now denied, the grand jury is free to hear her testimony within days. The grand jury in this specific case meets on Tuesdays and Thursdays, which is the standard schedule in the Southern District of New York, where this case resides. If the prosecutors are ready, and the existence of the proffer suggests they are, she could be appearing before the grand jury within the next 7 days, perhaps as early as this coming Tuesday. Once her testimony is on the record, prosecutors will face a strategic choice between two paths. The first option is to use her testimony to bolster the charges that already exist. The current indictment includes 34 counts of falsifying business records and bank fraud. Her testimony regarding signing joint tax returns, attending meetings with accountants, and corroborating other witnesses would significantly reinforce the case for the charges already filed. The second option is to seek a superseding indictment. This would involve adding entirely new charges based on the fresh evidence she provides. One particular item to watch closely is a conversation from March 2020 that she details in the proffer. She claims she was present during a phone call between the defendant and a banker where property values were discussed prior to a loan application. If that call involved both of them making false statements together, him saying one thing and her confirming it, while both knew it was a lie, that constitutes conspiracy to commit bank fraud. Conspiracy is a crime separate from the fraud itself. It requires an agreement between two or more people to do something illegal, plus at least one concrete step toward making it happen. A phone call where two people knowingly lie to a banker is the agreement. Submitting the loan application is the concrete step. If prosecutors believe they can prove conspiracy through her testimony, they will likely pursue these additional charges. A superseding indictment would add new counts and could drastically increase the defendant's legal exposure. The trial is currently set for September 16th, which is 28 weeks from now. With the Supreme Court appeal denied, the toolbox of delay tactics is empty. There are no more emergency motions to block evidence and no more privilege claims to argue. That trial date is going to hold. This case establishes three precedents that could ripple through federal prosecutions for decades. The first precedent is spousal cooperation at the absolute highest levels of power. We have seen spouses cooperate in organized crime cases. Back in the 1980s, prosecutors relied on wives testifying against husbands to bring down mob families. Sammy Gravano's wife cooperated, as did Henry Hill's wife in the real-life case that inspired the movie Goodfellas. We have also seen spouses cooperate in massive corporate fraud cases. During the Enron scandal, the spouses of multiple executives testified, but never before have we seen this at the presidential level, where the spouse of a former commander-in-chief comes forward with financial records, private communications, and direct testimony that implicates them in federal crimes. This fundamentally changes the game for future investigations. If a federal prosecutor is building a case against a powerful official and knows the spouse shares legal exposure because they signed documents or attended meetings, they now have Supreme Court confirmation that spousal privilege cannot block voluntary cooperation. The second precedent is that the Supreme Court's rapid response sends a loud message. Privilege claims will not be allowed to delay federal cases. That one-sentence rejection with 0 dissents set a standard. When spousal privilege is voluntarily waived, emergency appeals based on marital privacy will not succeed. The courts will not allow delay tactics to be masqueraded as constitutional arguments. This is a critical development for every future white-collar crime case where spouses share financial liabilities. Defense lawyers now understand that privilege claims are not a viable strategy for buying time when the witness has chosen to flip. The third precedent is that accountability applies regardless of wealth or power. For decades, wealthy defendants have utilized procedural tactics to stretch cases out with endless appeals, privilege claims, and emergency motions, hoping to simply outlast the prosecutors or wait for the political winds to shift. This case demonstrates that the system can still function when the courts act with decision. The judge kept a strict schedule. The Supreme Court unanimously rejected the delay tactics. The grand jury process moved forward without interruption. The court said no. The judge said no. The law was applied equally, and the system worked because the institution stood their ground. As we look to the next 30 days, there are three specific things you should watch for that will reveal the prosecution's strategy. First, keep an eye on grand jury activity. If new witnesses are subpoenaed within the next 2 weeks, it means prosecutors are building toward new charges. The pattern of subpoenas will tell the story. More witnesses usually mean more counts. Second, watch the defense team's response. They will almost certainly file a motion to suppress her testimony, which is standard procedure. But what matters is their focus. If they attack the recordings, it means the recordings are damaging. If they attack her credibility, it implies the documents are irrefutable. Defense motions often reveal exactly what the prosecution's strongest evidence is. The third thing to watch is the finalization of the immunity agreement. The proffer is just step one. Full immunity requires a signed cooperation agreement, a formal contract that spells out exactly what testimony is required and what protections are given in return. When that document is filed, it will reveal the full terms, whether she receives full immunity, partial immunity, or use immunity, which only protects the testimony itself from being used against her. The Supreme Court did not write an opinion today because the law was already settled. Spousal privilege can be waived. Evidence will be heard. No one is above the law, not because of their bank account, not because of their privilege, and not through the use of endless appeals. The system worked today because the court followed established precedent. If you found this breakdown informative, please consider sharing this video with someone who needs to understand the facts behind the headlines. Thanks for watching.